I have had involvement with two references conducted by the Australian Law Reform Commission. The first was a reference concerning the protection of human genetic information. The second was a reference concerned with the law, practice and management of discovery in litigation in federal courts. I was a member of the advisory committee for the first reference and was an ad hoc member of the Commission in connection with the second reference. In both cases, I experienced the depth of competence and devotion of the staff of the Commission to the work in which they were engaged. I expect that my involvement in the first reference arose because I had begun to exercise jurisdiction as a judge of the federal court in patent cases. The reference involved the joint conduct on inquiry by the Commission as well as the Australian Health Ethics Committee, and was concerned with whether and to what extent a regulatory framework was required to protect the privacy of human genetic information, to provide protection from inappropriate discriminatory use of such information, and to reflect the balance of ethical considerations relevant to the collection and use of such information in Australia. The inquiry involved a consideration of the complex interaction between the law, ethics and science. That in itself was a fascinating experience. As a lawyer, one does not often have the opportunity of such interaction. The inquiry resulted in a report in 2003. The report highlighted the tension between public support for scientific breakthroughs promising better medical diagnosis and treatments, and public anxiety about increased loss of privacy and the potential for genetic discrimination. The second reference resulted in a report of 2011 dealing with the much more mundane but vexatious problem for litigation of managing discovery in complicated disputes. The Commission made a number of recommendations, several of which required legislation that was subsequently enacted by amendment to the Federal Court of Australia Act. I look forward with interest to see whether the recommendations will have any practical effect on the age-old problems that judges and litigants have experienced with discovery. Having ceased to be a trial judge, after attaining constitutional retiring age, I will not have the opportunity of practical involvement in the implementation of the recommendations. Both references related to the first of two aspects of law reform, namely the extent to which current law should be changed to meet changing community requirements and standards and developments in technology. That aspect of law reform requires a deep analysis of policy that in turn involves interaction with the executive government insofar as there is unlikely to be reform by the Parliament without the support of the executive government. Of course, as a practical matter, there will be no reference to the Commission unless the executive government is of the opinion that a task should be undertaken. The tasks that are undertaken will very much depend upon the philosophical outlook of particular governments. The other aspect of law reform is the reformation of the law without necessarily changing its effect. Reformation, in that sense, has the object of clarifying the law rather than changing it. Reformation, in that sense, is sometimes described as codification, a term derived ultimately from the great reformations of the lawmakers of ancient Rome. The word code is derived as a matter of etymology from the word codex, a Latin word signifying the physical manner in which material is collected. Originally, extensive material was recorded on a scroll. codex was the initial form, what we would today call a book, a form that enables one to move more easily backwards and forwards between the material by turning pages. The codex was the form in which the Romans produced their reformations of the law, particularly collections of statute law. The object of such reformations was to collect in one place an authoritative restatement of all current statutes. That kind of reformation has occurred regularly in modern Westminster systems. It has been common practice since the end of the 19th century to collect current statutes in a single series of volumes. Today, the same function can be performed much more conveniently by means of digitisation. A much more ambitious reformation of the law would be to embark on restatements such as were undertaken by the reforms of Justinian in the 6th century. In ancient Rome, the writings of the jurists had the same authority as the judgments of judges under our common law system. By the 6th century, there were tens of thousands of juristic writings and authoritative opinions that made it very difficult for citizens to know precisely what the law was. Justinian directed the compilation in a single work, commonly known as the Digest or the Pandects, of an exhaustive restatement of all judicial and juristic writings. He gave detailed instructions to a law reform commission to compile the Digest in 50 books, and directed that thereafter that restatement was to be authoritative for all purposes, and no one was permitted thereafter to refer to any of the earlier writings. In the 17th century, Francis Bacon advanced a similar solution for England. The great civil codes of Europe of the 17th, 18th and 19th centuries derived from the Prussian and Bavarian codes and culminating in the Napoleonic Code, followed in the Justinianic tradition. While there have been limited attempts to undertake such codification in the common law in particular areas, such as sale of goods, bills of exchange, evidence and the like, and there have been private attempts to restate the law in publications such as Halsbury's Laws of England and Halsbury's Laws of Australia. No one has contemplated such a mammoth task in Australia. That is the real challenge for law reform in the future.